Well, good morning to all of you. As the board indicated, we're going to do a little presentation here. Some of you might have seen it before, some of you might not. It's on the Bulletin, the Bulletin 2010-4 that Robert Commodore and Charlie Dernberger are going to be here to address some questions on. Now, when I talk about it, I'm going to talk about it from my perspective as a construction lawyer. And I'm going to talk about it as to what the Bulletin says. What the Bulletin says you can do, what the Bulletin is silent on, so it becomes a gray area issue or a question of whether you can do those activities, and what the Bulletin absolutely says you cannot do. I don't have the answers beyond that, and that's another reason why we have the state coming in to add some clarity on this issue. But as far as I'm concerned, and as far as questions for me, I'm going to take them afterwards. And really, they're going to be questions that are more appropriately addressed to the state officials that are going to be here after we get done with this presentation. But I wanted to give a little bit of history first as to what's been done to this industry, because I've been representing contractors now for 14 years as a lawyer, and it used to be that we rarely ever had law changes that affected your industry, which was a good thing. We had stability. We knew what things were. We knew what the contracts had to say. We knew what procedures you had to have. We knew what you could do and what you couldn't do. And it seems that in recent times, the last several years, there have been change after change after change. And some of you might sit out there cynically and say, well, that's great for a construction lawyer, right? Because it gets us a lot more business. Well, it is and it isn't. The bad news is, just as it's bad for you because there's uncertainty of what you need to do, it's also bad for us, because if you are driven out of business because of all these law changes that directly affect you, the suppliers that supply you, the service providers like the insurance industry, like lawyers, other service providers that provide to you, we're also hurt too. So these law changes, we're all in this together, and this does not bode well for any of us. But I do want to give a little history here as far as some of the recent changes. So as an overview, we're going to talk about this Bulletin 2010-4. But before that, we're going to talk about the coming storms. Laws, they are changing, and they have been. And they are going to in 2011 as well. Those have already been passed. So we're going to talk briefly about that. I'm going to give a little background on the regulation, the regulators, what Commerce Department does, what Department of Labor and Industry does, and how that affects you as it relates to this bulletin. And then what are current practices in your industry, because they are going to be affected, and they are affected by what this bulletin has done. What are acceptable practices according to the bulletin? What are questionable practices according to the bulletin? And what practices are you currently engaging in that are absolutely prohibited by this bulletin? And then we'll have a takeaway, and what's the effect of this bulletin, and what do you need to do to change things so that you are compliant with it. And then we're going to talk about briefly the 72-hour cancel notice, which is also referred to in the bulletin, and then the deductible rebates. You can't rebate deductibles on roofing insurance jobs, residential roofing insurance jobs. So that's also in the bulletin. And then finally, we're going to talk about there's a need for legal clarification. This is not clear. The bulletin isn't clear. The law isn't clear. And we need clarity so that we as construction lawyers can properly advise you, and you as contractors, you have that certainty that you know you're doing things right, because you're not out there trying to do things wrong. You're working hard, but they're making this difficult for you. So laws, they are changing. The things that have happened to you so far in 2007, in recent history, 2007, the ICEC law was put in place. The ICEC law says that if you have individual subcontractors that are out swinging hammers for you, they need to have an independent contractor exemption certificate. In 2007, there was a change in what's called the statute of limitations, statute of repose. That's a very technical issue, but basically they extended the time period that you can get sued for warranty claims. In 2008, the EPA came out with its lead rule that all of you are getting dealt with now this year, because it went into effect in 2010, but that was passed in 2008. And then in 2008, now the law we just talked about, the ICEC law, was clarified. It was passed in 2007, while they clarified in 2008. Clearly, it wasn't clear enough in 2007, and they had to make changes immediately to it. There was an exception put in for landscaping, for example. That lobby obviously is organized because they got an exception. It would be nice if you're organized so that you don't have these things that affect you. In 2009, the Subcontractor Bill of Rights was passed, and that law says basically when your subcontractor who's out swinging a hammer is done with their work, you have to pay them within 10 days of the completion of the work and you're being paid. There's some other parts to that law too, but that's a big deal, 10 days. It's my understanding like a Walmart or a Target, they take up to 3 months to pay or 4 months to pay their accounts receivable. You have 10 days. This is specific to the construction industry. In 2009, the 327A warranty, which is the typical 1, 2, 10 warranty that you all should be familiar with by state statute, 1 year workmanship, 2 year mechanical systems, 10 year structural. That was changed, and now where in the past you had to give it to them, well, you didn't have to give it to them in the past, it was implied in your contracts, now you have to give it to them in writing, and that was passed in 2009. So it made it what's called an express warranty rather than an implied warranty. In 2009, the ICEC law, we've already talked about it twice now, was again clarified. They added a task force to investigate relating to ICEC compliance and that sort of thing. And then in 2010, we had the EPA-led rule was changed again. There was an opt-out provision that was in the rule that was eliminated. So basically, all pre-78 projects where children are present, like or could be present, you have to follow the EPA rules regardless, and they can't opt out of that, where the rule before had an opt-out provision. In 2010, the EPA was the ICEC law was clarified again as far as what information needed to be provided to apply for it. Now, it's kind of humorous to me because there isn't a lot of people that's applied for ICEC certificates. Most people went and got set up with entities, a corporation, an LLC, which is an exception to this ICEC rule. But clearly they're strengthening this rule. What does that tell you? Does that mean that they're going to try to eliminate the exception, the entity exception, where you can if you're a corporation or an LLC, you're accepted from coverage under this thing? All they'd have to do is change a couple words in this statute, and if they do that, every subcontractor is going to need to get, in a sense, licensed. They're going to need to get an ICEC certificate. I don't think it's just out of the blue. I don't think they're sitting around with nothing to do and why they're strengthening and clarifying this law. If your voice doesn't get heard, if your lobby isn't effective, I expect in the future, because of this history here, you're going to get rolled. And you're going to get rolled where things like this are going to be changed and they're going to be made more severe. They're going to require, and again, I'm not saying this is for certain, but they're going to require corporations and LLCs to get licensed. Other states do have that. Now in 2010, the thing we're going to be talking about this morning, and we have the officials from the state speaking on, is this Bulletin 2010-4, issued by the Department of Labor and Industry and the Department of Commerce. That specifically affects your industry, not just construction, your segment of the industry, renovation contractors. 2010, no deductible rebates on insurance-paid roofing jobs for residential roofing. 2010, 72-hour notice of cancellation on insurance roofing jobs. 2011, these have already been passed, so look for them. They're going to come into effect in January. You have to have performance guidelines in your contracts. What are they looking for? The law doesn't tell us. They don't say in the law, they don't define what performance guidelines means. So right now it's Wild West. What kind of performance guidelines do you want to have? You're going to have something. You're going to have it in your contract come January, but we don't know what the heck they want us to put in there. 2011, EPA certification in Minnesota. To be able to pull permits on pre-78 housing, you're going to need to show that you have EPA certification, that your firm has certification. If you can't show that, you don't get to pull permits. 2011, warranty claim arbitration. So now, under a 1-2-10 warranty, if your customer has a problem after you've done your inspection, because you do have a right to inspect. You don't have a right to repair, but you have a right to inspect. If they reject that, beginning in 2011, it's going to go into automatic arbitration regarding scope of repair. And that's it, that issue alone. If you can't resolve it through arbitration, then it's going to go to court. Well, to me, that's going to make the process more expensive. You're going to go through arbitration, you're going to spend money for that, and then you're going to go to court if you can't resolve it through arbitration. It's another hurdle, it's another expense, and it's coming in 2011. It's a little hard to see there, but that's hail. That's hail on a roof. This is Bulletin 2010-4. This is what we're dealing with here today. But this isn't the only thing that we're dealing with, and I went through a laundry list of things that have changed and are changing for you recently. On background, the Minnesota Department of Commerce, they regulate the insurance companies. They regulate the adjusters, public adjusters. They used to regulate you guys before it got transferred to the Department of Labor and Industry a few years ago. Minnesota Department of Labor and Industry, they regulate you guys. You are a licensed industry for residential contractors. Public adjusters are a licensed industry. Insurance companies are a licensed industry. Why is that important? Because with this Bulletin 2010-4, with them both departments issuing it, so they both signed off on it, recognize that this bulletin is not law. This bulletin is an interpretation of law. Why is that important? Because the interpretation guides the departments in their enforcement activities. So when they're looking at you as a contractor, are you engaging in practice that they consider illegal or unlawful, where they can take a licensing enforcement action against you? They're going to use this to interpret whether they're going to take action. That's why they issued it. They issued it to tell the industry, be careful, because if you step across these bounds, we can come after you, and we will. But it's not law. It's an interpretation of law. And that's important because the legislature, administrative law is law. I mean, they can issue regulations, and that becomes law, but there has to be regulations issued under a law that was made by the legislature. Courts can make law, but this bulletin itself is not law. The problem is as far as licensing, licensing enforcement, this bulletin is important, and that's where it is important. You could get pinched. And as far as your licenses are concerned, it's up to $10,000 per violation. For the public adjuster statute, it was $500 per violation. But because you're licensed contractors, you could get hit with a $10,000 fine. That's a big deal. And so you want to comply with this thing, because you don't want to be in a licensing action if you can avoid it. So current practice, what has been done until this point in time? In about 98, 99, when we had a big storm, the out-of-state stormers came in, and before that, most contractors were doing work on a bid basis. And the stormers came in, and there was just a whole brand new way of doing things. And that was where this price agreeable contracting sort of occurred. With this price agreeable contracting from this, what the stormers did, everyone sort of adopted this practice. And so you have a storm that occurs, and your sales reps go out and they canvass the neighborhoods, and they get signed a price agreeable contract with the owner of the property, which also is the insured. And the typical mantra, in a sense of it, is that you'll have no out-of-pocket expense except for your deductible, and we'll only do the work if we reach a price and scope agreeable with the insurance carrier. If we don't, you're not going to have to pay us anything. If we do, then we're going to do the work for that. And again, no out-of-pocket cost except for your deductible. And the damaged improvement, the house or the building or the business or whatever it is, becomes your inventory under this prior practice. And so you, in a sense, you're the one that works up the claim. And the price and scope, if it's agreed upon, you perform the work. And if it's not, you don't. And that was the practice that again started with about 98, 99 when the storm that came through brought in a lot of the out-of-state stormers. And that's kind of the way we've been operating until this 2010-4 bulletin came out. So then we get hit with this bulletin, and the bulletin does lay out some acceptable practices, and the bulletin does lay out some practices that are prohibited. And the bulletin is silent on a lot.